relationship between persons arising by descent from a common ancestor. See relative. Entire blood. See full blood. Full blood. 1812 The relationship existing between persons having the same two parents, unmixed ancestry. Also termed whole blood, entire blood. Half-blood. L7c, the relationship existing between persons having the same father or mother, but not both parents in common. Sometimes written half-blood. See relative of the half-blood under relative. Cases, descent and distribution heritable blood. Hist. A relationship between an ancestor and an heir that the law recognizes for purposes of passing good title to property. Also termed Jane heritable blood. Cases, descent and distribution. Rightful, adjective. 1. Of an action, equitable, fair less than a rightful dispossession greater than. 2. Of a person, legitimately entitled to a position less than a rightful heir greater than. 3. Of an office or piece of property, that one is entitled to less than her rightful inheritance greater than. Right heir. See heir. Stock N. L4C 1. The original progenitor of a family, a person from whom a family is descended, branch 1, less than George Harper Sr. was the stock of the Harper line greater than. 2. A merchant's goods that are kept for sale or trade less than the car dealer put last year's models on sale to reduce its stock greater than. 3. The capital or principal fund raised by a corporation through subscribers' contributions or the sale of shares less than Acme's stock is worth far more today than it was 20 years ago greater than. 4. A proportional part of a corporation's capital. Represented by the number of equal units, or shares, owned, and granting the holder the right to participate in the company's general management and to share in its net profits or earnings less than Julia sold her stock in Pantheon Corporation greater than. See share 2. Cf. Security. 4. Cases, corporations C. J 63.1. Subrogation S. B. R. Gay Shush N. N. I 5 C. 1. The substitution of one party for another whose debt the party pays, entitling the paying party to rights, remedies, or securities that would otherwise belong to the debtor. Subrogation is equitable assignment. The right comes into existence when the surety becomes obligated, and this is important as affecting priorities, but such right of subrogation does not become a cause of action until the debt is fully paid. Subrogation entitles the surety to use any remedy against the principal which the creditor could have used, and in general to enjoy the benefit of any advantage that the creditor had, such as a mortgage, lien, power to confess judgment, to follow trust funds, to proceed against a third person who has promised either the principal or the creditor to pay the debt. Lawrence P. C.M.P. Sun, Handbook on the Law of Suretyship 205, 1950. Subrogation simply means substitution of one person for another, that is, one person is allowed to stand in the shoes of another and assert that person's rights against the defendant. Factually, the case arises because, for some justifiable reason, the subrogation plaintiff has paid a debt owed by the defendant. Dan B. Dobbs, Law of Remedies Section 4.3, at 404 2d ed. 1993. Prima facie privilege. See qualified immunity under enmity 1. Prima facie, adjective. 18c, sufficient to establish a fact or raise a presumption unless disproved or rebutted less than a prima facie showing greater than. Prima facie, pn ma facie or facie, adv. Latin L5c, at first sight, on first appearance but subject to further evidence or information less than the is prima facie valid greater than. Cases, evidence 584 1. Primi impressionis pn me impre beeo nis. Law Latin, of the first impression. See case of first impression under case. Primi preces. CPRECESPRIMARIAE. Jensen Doctrine. Maritime Law. The principle that a state statute may not apply in a maritime case if to do so would work material prejudice to the characteristic features of the general maritime law or interfere with the proper harmony and uniformity of that law. Southern Pac. Co. V. Jensen 244 U.S. 205 37 S. Court. 524 1917. Cases Workers' Compensation 262. Jumping a claim. Hist. The act of taking possession of public land to which another has previously acquired a claim. Underscore the first occupant has the right to the land both under squatter law and custom and under preemption laws of the United States. Jus divinum, J.S. Divi NCLM. 1. See divine law. 2. See natural law. Jus primi noctis odds prj me noctis. Latin, right of first night, see droit du seigneur. Jus praesens, J.D.s praesens or zens, 11. Latin, present right, civil law. A right that has been completely acquired, a vested right. Droit dra n. Law French, double right, hist. The unification of the right of possession with the right of property. Also termed jus duplicatum, driat. Driat, a complete title to lands, tenements, and hereditaments, for it is an ancient maxim of the law, that no title is completely good, unless the right of possession be joined with the right of property, which right is then denominated a double right, jus duplicatum, or droit. And when to this double right the actual possession is also united, then, and then only, is the title completely legal. 2 William Blackstone, Commentaries on the Laws of Eng, and 199 L. 766. Droit du seigneur, droit seigneur. French right of the lord, hist. 1. A supposed customary right of a feudal lord to have sexual intercourse with a tenant's bride on her wedding night. 2. A supposed custom requiring sexual abstinence by a couple on their wedding night. Also spelled droit de seigneur. Also termed jus primi noctis. Wardship in copyholds. Wardship by which the lord is guardian of an infant tenant by special custom. Ward of Admiralty, a seaman so called because of the legal view that a seaman, in contractual matters, should be treated as a beneficiary and the other contracting party as a fiduciary because of the perceived inequitability of the bargaining positions. Cases, Seaman, J1. Tubman, Tab M.M. Hist. A junior barrister in the Court of Exchequer who made motions that were second in precedence to those of the postman. The tubman was so called because he stood by a tub anciently used as a measure of capacity. Cf. Postman. Presumption of paternity. 1829, Family Law. The presumption that the father of a child is the man who, 1. Is married to the child's mother when the child was conceived or born, even though the marriage may have been invalid, 2. Married the mother after the child's birth and agreed either to have his name on the birth certificate or to support the child, or 3. Welcomed the child into his home and later held out the child as his own. Also termed paternity presumption, presumption of legitimacy, legitimacy presumption. See presumed father under father. Cases, children out of wedlock C = 3. Laches, estoppel by. See estoppel by laches under estoppel. Laches, is. Law French, remissness, slackness, L4C1. Unreasonable delay. In pursuing a right or claim almost always an equitable one in a way that prejudices the party against whom relief is sought. Also termed sleeping on rights. L cases, equity, greater than 67. Early in its history, Chancery developed the doctrine that where the plaintiff in equity delayed beyond the period of the statute applicable at law, relief would be refused on the ground of laches even though no specific prejudice to the defendant was shown. Today, in most states, there are statutes of limitations applying to suits in equity. Despite these, however, the doctrine still holds that even if the delay is for a shorter period of time than that of the statute, it may still bar equitable relief if it is unreasonable and prejudicial to the defendant. John F. O'Connell, Remedies in a Nutshell 16 2d ed. 1985. International Parental Kidnapping Crime Act of 1993. A federal statute that implemented the Hague Convention on the Civil Aspects of International Child Abduction. 18 U.S.C.A. Section 1204. See Hague Convention on the Civil Aspects of International Child Abduction. Cases, kidnapping C = 24. Enticement of a child. Criminal law. The act or offense of inviting, persuading, or attempting to persuade a child to enter a vehicle, building, room, or secluded place with the intent of committing an unlawful sexual act against the child. Often shortened to enticement. Cases, infants = 13, enticement of a parent. Rare. Torts. The tortious interference with a child's rights and interests in maintenance parent-child relationship, usu. Caused by a third person who induces a parent to abandon the child. Actions based on enticement, where they're recognized, are rarely successful because many states do not recognize a child's legal right to a parent's consortium or affection. Embryo informatus, informatas. Eccles. Law. A human embryo before it has been endowed with a soul. Also termed embryo inanimatus. Embryo adoption. See adoption. Amend, VB. 15c to correct or revise, especially, to edit or change, a text. Emenda emenda n. Pi. Latin, amends, things given in reparation for a trespass. Emendatio emendatio n. Latin, hist. The power of amending and correcting abuses, according to certain rules and measures. Black Acts. Scots law. Statutes of the Scottish Parliament passed from 1535 to 1594 and recorded in a book printed in black letter. Black Book of the Admiralty. English law. A medieval code of maritime law containing admiralty laws, ordinances, and proceedings, decisions, and acts of the monarch, the Lord High Admiral, and the Court of Admiralty. The Black Book is considered a definitive source for customary English maritime law. It also contains a copy of the Rules of Oleron, an 11th century compilation of common maritime law. Black Book of the Exchequer. Hist. A record book containing treaties, conventions, charters, papal bulls, and other English state documents. It dates from the L3th century. Also termed Liber Niger Parvis. Birth certificate. A formal document that records a person's birthdate, birthplace, and parentage. In all 50 states, an adopted child receives a second birth certificate reflecting his or her adoptive parents. In such a case, the original birth certificate is usu. Sealed and can be opened only by court order. Some states allow limited access, depending on the year when an adoptee was born and, sometimes, on whether the birth parents consent. The trend today is to open records if 1. Both the child and the biological parent consent, for example, through an adoption registry, or 2. The child requests and, upon notification, the biological parent does not veto the request. Oregon enacted the first statute to permit access to birth records upon the unilateral demand of the adopted child, once the child reaches the age of majority. See Adoption Registry Statute, L. Cases, Health 397. Bishop's Court. L. An ecclesiastical court usu, held in the diocese cathedral and presided over by the bishop's chancellor. 2. Hist. Eccles. Law. Cap. A court usu, held in the cathedral of a diocese, the judge being the bishop's chancellor, who applied civil canon law. The jurisdiction included appeals from the court of archdeacon. In a large diocese, the bishop's chancellor would have commissaries in remote parts who held consistory courts. See Consistory Court. Biting rule. A rule of construction that once a deed or will grants a fee simple, a later provision attempting to cut down, modify, or qualify the grant will be held void. Cases, Deeds 124, Wills 601-2. Birth. The complete emergence of a newborn baby from the mother's body. The quotation below states the traditional legal view of birth. In a few jurisdictions, the state of the law may be changing. In South Carolina, for example, a child does not have to be born alive to be a victim of murder. A woman can be convicted of fetal murder if a baby is stillborn because of the mother's prenatal drug abuse. For purposes of criminal law and also for those of property law, e.g. to become a holder of property and so transmit it again to new heirs, or to enable the father to obtain courtesy of his wife's lands, birth consists in extrusion from the mother's body, i.e. in having come into the world. If but a foot be unextricated, there can be no murder, the extrusion must be complete, the whole body of the infant must have been brought into the world. But it is not necessary that the umbilical cord should have been severed. And to be born alive, the child must have been still in a living state after having wholly quitted the body of the mother. J. W. Cecil Turner, Kenny's Outlines of Criminal Law 104 L 6th ed. 1952.